Hello viewers, you're welcome to another episode of Tommy Talks Legal, bringing the law to you in your language. Kindly subscribe to my YouTube channel, click on the like button, and thank you for sharing generously with your audience. So last week we spoke about tips on how to avoid toxic workplaces and toxic bosses. So today we will be doing a continuing episode of the toxic workplaces and toxic bosses. And today's episode has to do with your rights as an employee, why your contract of employment is important, and so on and so forth. Kindly join me as we go ahead. So, what are your rights as an employee? You are looking forward to working in an organization, or you're working in an organization. I've seen that one of the reasons why people's rights are easily violated is because people or employees do not know their rights. So when you do not know your rights, how do you want to fight for it? So what are your rights as an employee? Number one, first thing first, you are entitled to a written contract of employment. Two, you are entitled to your remuneration. When I mean remuneration, I mean your salary, your work pay. You're entitled to annual leave. You are entitled to a sick leave. If you're working 8 hours round the clock, you are entitled to an hour rest. So you should have a break of an hour during the day, during your work hours. So you are entitled to work hours. So you should be knowing that, okay, if I'm resuming at my workplace by 9 a.m., by 5 p.m. or 6 p.m., I should be getting off work, except you are doing extra time, which will also be paid for by your organization. As a woman, you're also entitled to maternity leave, even though there are legislations now outside the country, international standards, that entitles a man also to paternity leave. You are entitled to a sick leave. So if you fall ill in your place of work or during your employment, you are entitled to a sick leave with full pay. So these are the common rights of an employee. So it is only when you know these rights that you will be able to fight for them. You're also entitled to a conducive workplace, a conducive environment as an employee, an environment that allows you to be productive. So when you know these rights, what are the things you also need to avert your mind to? Like our first right that we mentioned for you as an employee is having your terms and conditions of employment written down in black and white, given to you as an employee. Now, why is this terms and conditions, or why is this employment contract so important to you as an employee? Now, your contract of employment is important to you because it protects you as an employee. It protects you because that is where you have your terms and conditions written. As we all know, where there is no law, there is no sin. So where your terms and conditions of employment are not written down, how do you know exactly when your employee rights are breached? Why also do you have to have your contract of employment? You need to have your contract of employment so as to know the expectations of your employer concerning you. And invariably, you as an employee, you know the obligations of your employer towards you, so that both parties have a proper understanding of their work relation. Why also do you need to have your contract of employment? It guarantees your job security. So which means every day when I wake up to go to my office, when I wake up to render my service, I know my mind is at peace. I know what to expect. As long as the terms and conditions of employment have not been breached, I know that I am going to my place of work to render my service in a conducive atmosphere. So these are the reasons why you need your contract of employment. So you don't wake up in the morning, you're going to work, you do not know what to expect. So if your employee is going to be terminating your contract of employment, you know that there are stipulated guidelines for that employer to follow. So it doesn't meet you or catch you unawares, especially when you have not breached the terms and conditions of your employment. It is also your right as an employee to terminate your contract of employment. So when you're terminating your contract of employment, because there are terms and conditions written down, you are able to follow the guidelines stipulated in your contract of employment in order to terminate. So you also, even while you're waking up in the morning and you're thinking, oh, I am tired of working in this place, you can go back to your terms and conditions, you can go back to your contract of employment, look at it, and know that, okay, this is the procedure I need to follow to properly terminate my contract of employment. So peradventure, if it happens that you do not have a contract of employment and you're like, so am I without remedy? I have fallen short of my rights. Does it mean that you're at disadvantage? No, it may not be. However, it may be very difficult to prove your case when there is no written down terms and condition, depending on the peculiarity of your situation, of your challenge, or of your employment. Now, when you get your terms and conditions of employment, when you get your contract of employment, I always advise employees that carry your lawyer along. Why is it important for you to carry your lawyer along? Number one, it is only your lawyer that would know the enforceability and how lawful the terms and conditions of your contract are, or the terms and how lawful or enforceable the terms and conditions of your employment is. So as a layman who decides to read his terms, who decides to read his contract of employment and just put your signature out of desperation that you need an employment, or out of excitement, it is only your lawyer that will be able to look at the terms and conditions of your employment with objectivity and the future in mind, and will be able to fish out the loopholes in the contract on your employment for you and place it to you in the language that you will understand, and give you grounds to negotiate with your employer. Now, what other reasons do you have to seek a lawyer to review the terms and conditions of your employment? It is only your lawyer that will be able to interpret the expectations and the obligations of the employer and the employee in proper perspective. So when you have gotten all this in place, and it happens that your contract of employment has been breached, or your terms of employment has been breached, what do? It is obvious to us as lawyers that a lot of employees are always scared or nervous approaching a lawyer or suing or taking up legal actions against their employer. Yes, we understand, because we know that once you approach the court, you no longer come out as friends. But would you, because of that, not allow your rights to be trampled upon? So what should be your first approach if your terms of employment has been breached? Number one, seek audience. Seek the audience of your employer. Have a dialogue with them. Relate your concerns to them. If it now happens that you and your employer are unable to come to a consensus or an understanding or an agreement of whatever the situation may be, seek a lawyer. Consult a lawyer as to the legalities of your concerns. Oh, tell a lawyer, these are my situations. What is your advice for me? What are my chances in this case? Has my rights been breached? What do I do? It is only a lawyer that will be able to guide you on the approach or the positivity or on the outcome of your case if you approach the court. Now, if this has been ascertained, my dear employee, approach the court. Seek legal remedy for your right that has been breached. Now, if this episode has been insightful, educative, and eye-opening for you, kindly click on the like button, subscribe to our YouTube channel, and thank you for sharing generously with your audience as we bring to you another episode next week. Don't forget, Tommy Talks Legal, bringing the law to you in your own language. If you have comments, questions, please drop it in the comment section below, and be sure I will be there to respond to you. Thank you.